Yes. But the sole appellant Mulad has passed away. We filed an application Mulad for substitution. So, but that is IA number 8594 of 25.
But before my friends opens his argument, sorry.
Just a moment.
859. Yes.
Yes, it's only for substitution round.
That may be allowed. My respectful submission is that the writ appeal is not maintainable. Because the order under challenge is passed by the Honorable Single Bench in exercise of power under Article 227, and not under Article 220.
That is already taken up on 16.
No. The Honorable Court has been pleased to record, that an objection has been recorded, but that has not been dealt with by the Honorable Court.
My submission is substitution be allowed,
Just a moment. Yes, that has not yet been decided.
Man, we just have that order,
Yes.
So, 1612.
Yes.
It was actually argued at length, though it does not say it is overruled or not, and it was stated that brief note on written submissions, so it was stated that it will be argued. Let them have that arguments on maintenance.
If it is under 227, how does it become?
No, it is not under. May I just point out there were two petitions, one under 226, one under 227. One was an order, whereby there was a
One was a WP. And one was an MP.
And both were filed by learned friend, and both of them were clubbed together. If you Lordship, we just have the second para of 161224. 161224 only.
Yes.
Counsel for the appellant has pointed out that the said respondent number 6 filed WP 36211 of 24 under 226 of the Constitution of India, and MP number 6420 of 24 filed under 227 of Constitution of India. However, during pendency of the petition before the learned single judge, at request of respondent number 6, so that's him. He made it.
It's only a common order that has passed.
And
what is the difference between the MP and the WP?
One MP is against an interim order of custody, whereby I was granted custody. So my learned friend filed a miscellaneous petition. The other was an order passed by the subdivision officer, whereby an order was passed in terms of 102 of CRPC, because they were not handing over custody. So a second petition was filed challenging that
custody
order.
of what? Land, is it?
No, custody of the
minor child of 2 years.
2.5 years, I am for the maternal side, and the paternal side is facing prosecution under 304B. And the mother had given a statement, the father was behind bars, the mother-in-law was behind bars, and the father-in-law, the father of the child was behind bars. The mother-in-law, and the father, all of them were accused. So I am for the maternal side, unfortunately, during the entire pendency, the Nana, that is the maternal grandfather, he passed away. He was prosecuting it. So now the maternal grandmother as well as the mama.
And MP was for what?
I'll just explain,
MP was
regarding. If I may just address my objection,
MP. There was an interim order, whereby the custody was granted to me.
In what? In the
Guardians and Whatsapp petition.
That was in the MP.
In the
MP, all right.
So there was an interim order passed, regarding custody being given to me on the ground, that I am, as far as the welfare of child is concerned.
In the MP, in the miscellaneous petition.
Yes, that was an order passed under the Guardians and Whatsapp.
No, wait. That prayer was in the MP or the prayer was in the WP?
I'll just point out, there was an interim order by the family court, under Guardians and Whatsapp, granting me the custody.
That was challenged in
That was challenged by my learned friend in a miscellaneous petition.
All right. Then?
Now, after that, when the order was passed, they were not, despite the order being passed, not complying with the order. So we made an application before the subdivision officer under 102 of CRPC for implementation of the order, as well as the custody be granted to me, because there was an order passed by a competent court. So they appeared, and the subdivision officer, by virtue of an order, handed over custody, to me. So they challenged that in the writ petition. So both the petitions, the miscellaneous petition and the writ petition was filed by my learned friend. Both of them. So one against an interim order passed by the family court.
Now what happened? What was the order given in the MP, in the miscellaneous petition?
The miscellaneous petition, set aside the order passed by the family court and said that the custody should be handed over to the paternal side.
Maintainable. Now, how do you make it maintainable? Because the WP that arose was for the purpose of execution of the order passed by the
Yes,
under the
I'll
Guardians and Courts
point.
Act.
Yes, my lord. I'll
And
point.
that was refused, that was turned down by the SDM, so that against that order, the SDM, you came in WP.
My lord, I did not. My lord, both the petitions were filed by my learned friend only.
All.
Now,
What
my
about-
learned friend, yes, my lord, both the petitions by my learned friend, both of them were clubbed, my lord, on the prayer made by my learned friend. And then, my lord,
Maybe,
yes,
but
yes,
now, since the order passed and the MP has set aside the order given by the lower court under the Guardians and Wards Act.
yes, my lord.
That is the main order. That is the main
My lord,
order.
my submission is, my lord,
It's
yes,
not
my lord, I'll
correct.
point out, my lord, we argued that in the last
Do it
bit.
right now.
My lord,
Do
my
it right.
submission, may I just point out? My lord, as far as, my lord, this application under 22(3) is concerned, because, my lord, it cannot be, I cannot even argue because it's a dead person now. The appeal is, my lord, by a dead person. The substitution we made, it be kept next week, my lord, I'll argue. Both on, my lord, maintainability, because this was taken up last week as well. Now, your lordship may just have 1612. Why I'm saying that? Last time, my lord, missing.
Yeah, I'm looking at 16.
Parties are directed to file a brief note on written submissions along with case law citation relied upon relevant portions highlighting for convenience of the court. So it was the case that both the things, my lord, it would be argued on, my lord. My learned friend may point that out, my lord, but it was.
Pending since 16/12/2024.
Yes, yes, my lord.
Unless-
I've already uploaded my written submissions as well. I've already uploaded
May
my
I make
written
just
submissions.
two submissions, my lord, with my lord's permission?
All I'm
My lord,
submission-
the correct facts have not been put forth, my lord. My lord, the interim order was granted, my lord, by the family court, transferring the custody from the paternal grandparents to the maternal grandparents.
You are for the paternal grandparents.
For the paternal grandparents and now, my lord, for the father as well. Now, my lord, an interim order, my lord, absolute incorrect order, my lord. The custody was transferred from the custodial grandfather to the maternal grandfather.
That's what I said.
Now, my lord,
By the?
by the family court, my lord. Now, my lord, that order was essentially under challenge. Now, my lord, what my friend is saying that we did not comply with that order. My lord, within a span of 1 day, my lord, because the brother-in-law of the son-in-law, my lord, of the present appellant, my lord, he happens to be a collector. Now, by misusing his force and power, my lord, the SDM has executed an order passed by the
After how
family
many
court.
days of the order?
Within 2 days, my lord. Just
We
within
find
2
the
days.
application before.
Yes, my lord. Within 2 days, my lord, the SDM executes an order of the family court. So, my lord, I had no occasion, my lord, to wait for that order. My lord, I had to challenge both the orders.
No, my
Now,
lord.
that order was under challenge, my lord. The Honorable Writ Court, my lord, has essentially set aside the order of the family court, and consequently, my lord, the writ petition has been allowed. Now, my lord, I'll just point out one paragraph from the writ appeal itself, my lord. Just one paragraph, my lord. The grounds, my lord.
Lord, may I just
My
say
lord,
one
एक second,
thing?
एक second, एक second.
Let's complete, yes.
My lord, grounds, para 3.1, my lord. What my friend is trying to portray, my lord, what is trying to argue is, my lord, that the order of 227 has not been exercised properly by the Honorable Writ Court. When he himself is admitting, my lord, that order under challenge and under 227, my lord, writ appeal would not be maintained.
My lord, it's the other way around.
I would have listed the power of the contest and doing someone because another view is possible. You challenge that order under Article 227.
Yes.
You challenge the order passed under Article 227 by the single judge.
No, not me. My lord, my learned friend, my lord, may just point out. My lord, I'll point out, my lord, what.
No. Here in the writ appeal.
No, writ appeal
you
can't,
challenge.
not writ appeal, my lord, would be under the special act only, my lord, can't be under.
But can't be for administrative.
Yes. Now, my lord, may kindly appreciate, my lord, what my son.
I have not completed yet, my lord. The last part of
Alright,
the...
complete.
Sorry, my lord. Sorry to interrupt, my lord.
Yes.
My lord, because I just wanted to put the correct facts, my lord. Therefore, my lord, the order passed by the Honorable Writ Court may kindly be seen, my lord, the last paragraph. But the important is, my lord, what jurisdiction the Honorable Writ Court has exercised, whether under 226 or under 227.
Yes, I'm looking at it.
Thus, it is evident that since the child is not in a position to speak, obtaining his consent may not be possible, but merely reduction in weight of a child with his growth is not an unusual phenomena to come to a conclusion that he is not getting nutritious diet. Similarly, merely saying that the father and grandmother of the child are accused in a criminal case is not a sufficient circumstance to take away the custody of the child from his familiar atmosphere to put him in a trauma. Therefore, when tested on this ground, the impugned orders dated so-and-so passed by the second additional principal judge, family court, Bhopal, and order dated so-and-so passed by the SDO Govindpura cannot be given seal of approval. My lord, when the order of the family court goes, my lord, that the consequence is that the order of SDM automatically goes.
Yes.
This is what my
Order goes, the order.
this is what my respectful submission is.
Yes. Now, two submissions, my lord. One, my lord, as far as my lord to 227 and the maintainability is concerned, my lord, I put in 3 judgment, my lord, I'll put it again, my lord, because it is not the case that merely because it's 227, my lord, it would not be maintainable. There's a full bench decision on that.
But Supreme Court has said it's not maintainable.
As, my lord, we are arguing, my lord, what the Supreme Court says, my lord, I have submitted 2 judgments on that, that if there is a consolidated order, one under 226 and the other 227.
This is not consolidated.
My lord, I'll
These are
point that out as well.
This consequence of.
My lord, I'll point that out as well because we argued on both the petitions. My learned friend, my lord, imputed malice on the fact. So all I'm submitting.
You want to give a reply to his application?
My lord, my objection may
carry out the.
My objection.
Clear it all. Question of maintainability is satisfied.
My lord, question of maintainability be kept open. I have no problem. That is what it states.
Again, as there is no objection to the said IA for substituting the LRs in the place of the petitioner. Who are the LRs now?
My lord, one is the son and the other is the wife.
Son?
Son of the appellant and wife of the appellant. That is the maternal grandmother and the maternal uncle. Mama and my lord, Nani.
तब तो ये नाक की लड़ाई होगी.
नहीं, नाक की नहीं है, my lord, I'll point.
बिल्कुल नाक की लड़ाई anyway.
Parties are waiting for the
My lord,
legal
I'll
law.
point out, my lord, in fact, my lord, we'll go deeper in. My lord, I'll just point out.
There's always wherever these cases along this planet happens, it's always the child who suffers. Under the circumstances, the application is allowed. The name of the LRs be substituted in the place of the petitioner. Also, learned counsel for the petitioner is requested to make the necessary amendment to the 3 working days. Full stop. List after a week, fixed date under the same head for final disposal at motion hearing stage. Full stop. The of maintainability of the petition has to be addressed first.
Yes, there's one IA filed by me as well, my lord.
Yeah.
That the father, my lord, at the time when these proceedings were taken up, my lord, the father of the child, my lord, he was behind bars, my lord. Now, my lord, he has been granted bail. So, my lord, I have moved an application for that. He may also be implicated as a party, my lord, because, and I've even sought a direction, my lord.
You are for the father.
For the
Yes,
father and
we
the
are for the
petitioner.
father.
Both of you are for the father.
Together, we are for the father.
So, a similar application has been moved by the respondent. What is it? With the IA number so and so, which is an application
6320.
6320. Application moved by the father of the child who has now been enlarged on bail in the offence under section 304B. 304B. And has prayed that his name also be that he to be implicated as a respondent in this case. The prayer is reasonable. The counsel for the petitioner is requested to do the needful within 3 working days to ensure that the the applicant is included as a respondent in this case. This case would be then under the same head further.
Interim orders to cast.
I have ready to continue to the next rate of period.
Much.
Item number 12.